This will be kind of fast. This is it's called I'll put it in the description, the link, but it's the affidavit of Walker Todd, who's an intern. I'll get into it. Anyway, note here, right there where it says Harshavardhan Dave and Pratima H. Dave, but underneath it there's a care of address and defendant's improperia persona. That's how you want to come in court. You don't want to do it in per se or as pro se. And you want to have a CO address because again, they're not taking you, the person, to court, man. They're taking the straw man, the all caps name, to court, okay? So, the redemption process, you separate that entity from you. And one of the ways you do that, you get a registered address, a care of, or a care of address, or a suite or PO box. Anyway, it says, now comes the affiant Walker F. Todd, a citizen of the United States and state of Ohio over the age of 21, declares as follow, under penalty of perjury, that I am familiar with the promissory note, and this is kind of relevant, and disbursement request and authorization dated November, together sometimes referred to other documents. This is called the note. I make this affidavit based upon my own personal knowledge of the legal, economic, and historical principles stated herein, except that I have relied entirely on documents provided to me, including the note, regarding certain facts at issue in this case, of which I previously had no direct or personal knowledge. I am making this affidavit based on my experience and expertise as an attorney, economist, research writer, and teacher. I am competent to make the following statements. Professional background qualifications. My qualifications as an expert witness in monetary and banking instruments are as follows. For 20 years, I worked as an attorney and legal officer for the legal departments of the Federal Reserve Banks of New York and Cleveland. Among other things, I was assigned responsibility for questions involving both novel and routine notes, bonds, bankers' acceptances of securities, and other financial instruments in connections with my work for the reserve banks, discount windows, and parts of the open market trading desk function in New York. In addition, for 9 years, I worked as an economic research officer at the Federal Reserve Bank of Cleveland. I became one of the Federal Reserve System's recognized experts on the legal history of central banking and the pledging of notes, bonds, and other financial instruments at the discount window to enable the Federal Reserve to make advances of credit that became or could become money. I also have read extensively treatises on the legal and financial history of money and banking and have published several articles covering all of these subjects mentioned above. I have served as an expert witness in several trials involving banking practices and monetary instruments. A summary biographical sketch and resume include further details of my work experience. Ratings, publications, and education will be tendered to defendants and may be made available to the court and to plaintiff's counsel upon request. Generally accepted accounting principles. This is important. Banks are required to adhere to generally accepted accounting principles, which is GAAP, G-A-A-P. GAAP follows an accounting convention that lies at the heart of the double-entry bookkeeping system called the matching principle. This principle works as follows. When a bank accepts bullion, coin, currency, checks, drafts, promissory notes, or any other similar instruments, hereinafter instruments, from customers and deposits, or records the instruments as assets, it must record offsetting liabilities that match the assets that it accepted from customers. The liabilities represent the amounts that the bank owes the customer, funds accepted from customers. In a fractional reserve banking system like the United States banking system, most of the funds advanced to borrowers, assets of the banks, are created by the banks themselves and are not merely transferred from one set of depositors to another set of borrowers. From my study of historical and economic writings on the subject, I conclude that a common misconception about the nature of money unfortunately has been perpetuated in the U.S. monetary and banking systems, especially since the 1930s. It's like I was saying, it all changed in the 30s because we went off the gold standard. Anyway, in classical economic theory, once economic exchange has moved beyond the barter stage, there are two types of money: money of exchange and money of account. For nearly 300 years in both Europe and the United States, confusion about the distinctiveness of these two concepts has led to persistent attempts to treat money of accounts as the equivalent of money in exchange. In reality, especially in a fractional reserve banking system, a comparatively small amount of money of exchange, like gold or silver or official currency notes, may support a vastly larger quantity of business transactions denominated in money of account. The sum of these transactions and the sum of credit extensions in the economy, with the exception of customary stores of value like gold and silver, the monetary base of the economy largely consists of credit instruments. Against this background, I conclude that the note, despite some language about lawful money explained below, clearly contemplates both disbursement of funds and eventual repayment or settlement in money of account. That is, money of exchange would be welcome, but is not required to repay or settle the note. The factual basis of this conclusion is the reference in the disbursement request and authorization to repayment of such and such to Scooby-Doo. This was an exchange of the credit of Bank Scooby Snack for credit which Scooby... Ironically, the note explicitly refers to repayment in lawful money of the United States of America. It's the See Promise to Pay clause of the Constitution, that is. Traditionally and legally, Congress defines the phrase lawful money for the United States. Lawful money was the form of money of exchange that the federal government or any state could be required by statute to receive in payment of taxes or other debts. Traditionally, as defined by Congress, lawful money only included gold and silver and currency notes redeemable for gold or silver on demand. In a banking law context, lawful money was only those forms of money of exchange, the forms just mentioned, plus U.S. bonds and notes redeemable for gold, that constituted the reserves of a national bank prior to 1913. That was before the Federal Reserve Act. Date of the creation, I'll be damned. In light of these facts, I conclude that plaintiff and defendants exchanged reciprocal credits involving money of account and not money of exchange. No lawful money was or probably ever would be disbursed by either side of the covered transactions. This conclusion also is consistent with the bookkeeping entries that underlie the loan account in the dispute in the present case. Moreover, it is puzzling that why the plaintiff would retain the archaic language lawful money of the United States of America. It is in its otherwise modern-seeming note. It is possible that this language is merely a legacy from the pre-1933 era. Modern credit agreements might include repayment language such as the repayment obligation under this agreement shall continue until payment is received in fully and finally collected funds, which avoids the entire question of in what form of money or credit is the repayment obligation due. Legal tender, a related concept, but one that is economically inferior to lawful money. So that's what people understand. Federal Reserve notes, it says right there, it is legal tender. It's not lawful money. Because it allows payment in instruments that cannot be redeemed for gold or silver on demand, has been the form of money of exchange commonly used in the United States since 1933. When domestic private gold transactions were suspended until 1974, basically legal tender is whatever the government says that it is. The most common form of legal tender today is Federal Reserve notes, which by law cannot be redeemed for gold since 1934 or 1964 for silver. See 31 U.S.C. Section 5103. 51. That's what I said in my last video. Title 31 U.S.C. Sections 5103, 5118, subsection B, and 5119, subsection A. Note, I question not be redeemed for silver since 1964. It was Johnson who declared on 1967 that after who cares. Legal tender in the UCC codes is a concept that sometimes surfaces in cases of this nature. The reference official comment notes that the definition of money is not limited to legal tender under the UCC. Money is defined in section of Scooby-Doo as a medium of exchange authorized or adopted by a domestic or foreign government and includes a monetary unit of account established by an intergovernmental organization or by agreement between two or more nations. The relevant official comment states that the test adopted is that sanction of government, whether by authorization before issue or adoption afterward, which recognizes the circulating medium as a part of the official currency of that government. The narrow view that money is limited to legal tender is rejected. Thus, I conclude the UCC tends to validate the classical theoretical view of money. How big skin the lender? See, I don't want to read this. I'm already at like 10 minutes. Feel free and pause and read if you want.